This is Ceren from Internet Society European Bureau, and I will be moderating the session today. It is great pleasure seeing you all joining us online from different parts of the world. As you know, the EU General Data Protection Regulation is going to enter into force on May 25th. The GDPR provides new legal obligations to multiple actors involved, both within and outside the EU. And it is expected to change the privacy scene on a global level with its extraterritorial scope and heavy fines for non-compliance. Today, we have a great lineup of experts to discuss the GDPR and to share their valuable insights with us. We have Professor Joe Cannataci, who is going to join us shortly, the UN Special Rapporteur on the Right to Privacy. Bojana Bellamy, President of Hunton & Williams LLP's Center for Information Policy Leadership. Olivier Iteanu, founder and managing partner of Iteanu Advocates in Paris. And Nevena Ruzic, Head of Compliance Department at the Office of Commissioner for Personal Data Protection of the Republic of Serbia. Before we start with speaker presentations, I would like to turn to Sally Wentworth, Internet Society's Vice President for Global Public Policy, to join me in welcoming you with her opening remarks. Good morning, Sally. Thanks for joining us quite early.
It is quite early, but good morning from the US, or good afternoon or good evening to everyone. I'll just be very brief, but I did just want to echo Ceren's comments and welcome everybody. Obviously, the implementation of the GDPR is a very important sort of moment for many people in across the industry, really across the global economy, but for us specifically in the internet community, it's quite important. And I think the fact that we have, I'm watching the chat here and I see people from, I just saw Israel weigh in, and I've seen Argentina and Ethiopia and all across Europe. I think it indicates the level of interest and understanding what this means, what the implications might be. And particularly, as I said, for the internet community, what does this mean for the global internet and for privacy online and all of the other things that we care a great deal about? So we're just delighted that we have, I'm seeing we have about 140 people online so far, which is wonderful. And I just wanted to also thank our chapter advisory committee. They were the ones who asked for this on behalf of our chapters, really wanted to get a better understanding of what this all means. And the fabulous thing is that we can reach out to some really tremendous experts and get them to really talk to all of us in a virtual environment. We don't have to travel, and we can have this conversation as a global community. So I think this is really wonderful. For those of you in our chapters, you will have been receiving a number of communications from Todd and others in our chapter support group about implementation of the GDPR within the Internet Society and the things that we have to do. I just want to clarify that that's not what we're talking about here per se, but we are very committed to making sure that that goes well and smoothly in our own work and administration. But what we wanted to talk about here, and the reason we have this excellent panel, is to ensure that we all understand from a global policy perspective what this new set of regulations is going to mean for us in the internet community and you know how we go forward. So with that, I won't take any further time. I'll turn it back to Ceren and look forward to a very fruitful set of presentations and a good discussion. Thank you.
Thank you very much, Sally. I'm also looking forward for the discussion. Before we proceed, a quick note for the audience. There's a Q&A section available. If you wish to ask a question, please put that in the Q&A. We will also post a couple of poll questions for you during the session. Now we have to change our order a bit. Bojana, hope it's okay if we start with you. Thank you. We have your presentation ready. The GDPR aims to reintroduce the data subject into the equation in full charge of their own data and impose a wider range of obligations on data controllers, particularly with regard to transparency and accountability. Bojana, we know that the Center for Information Policy Leadership has worked on various projects related to the GDPR, and we would really like to hear more from you on the challenges and opportunities the GDPR presents. Thank you. Oh, you're on mute.
Okay, I am speaking on the phone. Can you hear me on the phone? Yes? Okay, I can't hear you, but I can see you moving. But I'm speaking on the phone, so as long as you can hear me, that's okay. I can't see my slides. If somebody can just put my slides up, I'm actually not able to see them on the screen, but hopefully the others can. So first of all, thank you very much for inviting me, Ceren, and it is excellent to see the work that the Internet Society and your chapter is doing. I'm delighted that GDPR has a wider impact and there is interest on GDPR wider than just the privacy community and those of us who work in organizations or regulators, because I do think it's going to have a wider impact on everybody. If we can move to the next slide, please. What I'd like to do today is first of all, share with you some of the insights from the work that the Center for Information Policy Leadership, CIPL, that I lead, has had around GDPR implementation. This is a project that we have launched almost 2 years ago, working with the data protection authorities and industry. And here is I'd like to tell you what we have learned in this project and where we are in terms of implementation at the moment. The first point is to say that this is going to be a big change for organizations who are going to have to change their systems, their policies, processes, how they use data about individuals. It is going to, of course, be a change for data protection authorities because they have to learn to work in a different way. And they have to learn to work in a European way beyond their national borders as well, because the GDPR brings a complete new change in the way they work. It talks about European Data Protection Board. It talks about one-stop shop and lead regulator and other regulators working in cooperation and consistency with that regulator. So that's going to be a real change. And you are going to see on this slide that Working Party 29, the current grouping of European regulators, has been extremely busy producing guidelines on the GDPR implementation. And those were the guidelines that mostly relate to areas where the GDPR required DPA to provide further guidance, but also some of these guidelines are simply clarification on some of the key new concepts under the GDPR. And I do advise you to have a look at the Working Party 29 website, because these guidelines are now available. And they're also there to help businesses and all kinds of organizations get ready for GDPR. And some of the really important ones on the role of data protection officer, because that is a new requirement, on the right to data portability, again, new requirement, on the notion of risk and high risk and how to conduct data privacy impact assessments, or very interesting guidelines on automated decision taking and profiling. Again, these are decisions taken solely by automated means that really will impact kind of how we do machine learning as well. So I think it's important that we know what the regulator's interpretation is, but also what the expectations of organizations are. There are some further guidelines which are at the moment in public consultation for those of you who are interested and want to be able to respond. And then there are going to be some further ones which we are going to see around the rules of procedure and as we get into the GDPR implementation. And I think that's really important to understand that these guidelines should be, in our opinion, evolving documents. And as part of our project, we have really been working with Article 29 and trying to sort of workshop and discuss each of the areas of the guidelines in advance of the guidelines, as well as we have responded as CIPL and our members to various guidelines that have been published to date. And it's important that these documents evolve as well, because frankly, until we start implementing GDPR, we are not going to see what the reality really looks like. There is a big debate whether GDPR is creating evolution in data privacy law or kind of revolution. My view is that while some of the rules are the same as what we have today, the reality to which we are applying these rules is very different. The world of digital society and digital economy, the connectivity, the Internet of Things, are just making these things more complicated, and the rules could be the same, but they have to be applied in a different way. Also, the rights of individuals are strengthened under the GDPR, and so we are going to see more activity there as well, more expectations from individuals as well. So if we can move to the next slide, please. I wanted to share with you some of the simple documents that our center published. They're all available on our website. Please go and read them, because they put forward interpretation on a number of these areas, but they also respond to Working Party 29 guidelines, and again, in some of the key areas of GDPR, such as transparency, consent, legitimate interest, the notion of risk, one-stop shop, etc. And we are continuing this work. It is very important that we do engage constructively with regulators, that we as industry talk about our implementation, what are the issues, what are the problems. And if we move to the next slide, please. We have asked our GDPR project participants, about 90 global and European organizations, to tell us about some of the perhaps challenges that they're seeing in implementing GDPR. And here I'm not going to drain this at all, but just, there is a paper on this actually on our website as well, if you would like to read a little bit more. But there's some interesting themes and topics here. Underneath sort of the overarching challenges, we hear from organizations, it is really important that there is this ongoing and direct dialogue between industry and data protection authorities and the future European Data Protection Board. This is really important. We are in an area of uncharted waters with this digital fourth industrial revolution. We have to work on some of these concepts together. There is also concern that regulators also have to be effective in the way they implement GDPR. They have to be well-resourced in order to be able to fulfill some of the objectives that are expected from them. So in terms of the call for guidance, industry, of course, appreciates guidance, but that guidance has to be timely. And, some of this guidance has been coming at very late stage. And those of you who are working in technology, you know that it takes very long time to reshape and rework business processes, to create new technologies, to aid compliance, and to implement these new requirements. And of course, Brexit is another thing that has specific concerns in kind of the family of European member states. And, I'm happy to kind of pick that up perhaps during Q&A. In terms of some of the substantive challenges, the GDPR implements this so-called risk-based approach to privacy regulation and compliance. And this is very progressive. It is something that we certainly welcome. And in fact, it was the center who has asked in the process of the legislative process that this is implemented. And what this really means is that there should be calibration of obligations. There should be calibration of compliance based on the risks and harms to individuals. Not all data processing has the same impact and harm on individuals. Therefore, organizations should be focusing on those areas where there is this higher level of risk and harm. But of course, how do you measure that harm? How do you decide whether something is high risk or low risk? That is going to be really practically, it might have some challenges, and that would be a hearing from organizations. The notion of legitimate interest processing, again, very important in this new digital revolution, where we cannot all the time base all processing on consent. And I think GDPR makes it clear that consent is only one legal basis to process data. There are others, and we have to be ready to use other legal bases and not just always put the burden on individuals. For example, equally portability, the right to data portability is a new right under GDPR. What does this apply to? How is it going to actually really be applied in practice? Giving individual ability to say, I want to move my data from one provider to another provider in a digitally consistent format. And so that, again, is going to require some system changes. And of course, operationally, organizations that have also say that there are areas there which require further guidance. What does it mean to do data protection by design, for example? How do we do records of processing? What is the role of these certifications? And how do we prioritize implementation tasks? Where do you start when you have to revamp your whole compliance program. So those were some of the challenges. But if we were to move to the next slide, I sort of want to really move away from the challenges and show you sort of where I think will be some of the key strategic areas for organizations in terms of GDPR management change. And I really look at it as a business person. You know, what do I need to do as an organization to get ready for this new reality? And in the core of GDPR is this new concept of data of accountability, which is incredibly important. And what that means is that organizations have to be responsible and accountable, have in place privacy program and policies and procedures, rules and tools to implement GDPR and to be able to demonstrate that they really do what they say they do. And you know, when you look at that accountability, all of these other areas of strategic impact become sort of kind of stemming from it. And starting from the left, of course, the need to have this privacy management program that is led by data privacy officer, this new appointment, which is not legally required, but however, most organizations will have to appoint somebody to manage compliance. The program has to be risk-based, has to be documented, has to be verifiable, and has to be demonstrated both internally and externally to regulators. The second area of strategic focus is the need to have a strategy for data transfers. As you very well know, data is global. Data is being transferred as I speak today. My data is going across wires and across national jurisdictions. And again, how do companies ensure that as data goes across the borders, that accountability and privacy protection follows with that data? That's really what is important. And this is a big area of compliance for big multinational organizations that they will have to rethink with GDPR. The third area is the area of data strategy, I call it. How do we ensure that we are able to leverage and use data to drive innovation, to drive new services and products, to kind of get the benefits from the data and digital? And that's why GDPR is so important. And I think this is probably the most strategic area, which I will talk a little bit at the end about. Again, how do we do risk assessments and privacy impact assessments? You know, that's going to be have to be documented, has to be systematic, has to be repeatable again. I put here this sort of new notion of privacy engineers. I think we are going to see in many organizations the need for the new breed. We don't need lawyers and project managers always. We need also people who are able to code and implement privacy by default and privacy by design. And so data scientists, our coders, our engineers have to be able to develop our products and services with privacy implemented from the start, because that's much better. That's actually is much more efficient as well. And I think smart organizations are going to be investing in this, and certainly lots of organizations that we work with at the center are developing kind of internal capabilities for privacy engineering. Vendor management is another important area because of the risk. As you know, the risk of data breaches, the risk of breach of privacy requirements multiplies as there is a bigger chain and ecosystem of people who are touching my data or my organization's data. So organizations are going to have to really tighten their vendor management programs. Many organizations are now redrafting their contracts and terms and conditions, and there is new requirements for also processors, for service providers, cloud providers, IT service providers under GDPR. They're going to have many more obligations as well. So I'm seeing a lot of work being done in this area. And then finally, you know, this is all about individuals. So individuals are going to have enhanced rights. I think there's going to be more awareness as well. We are going to see some new rights. And I think we will see more complaints and potentially even disputes. Hence, it is very important that we as organizations consider how we are managing relationships with individuals and these new rights, of course. And you also may have heard that there is this new right of sort of a class action where consumer organizations have rights to take companies to court for non-compliance as well. And so that's going to be to change risk profile, certainly in Europe. It's going to be more like what we see in the US, perhaps. Breach management is going to be another area where organizations are going to have to really invest a lot, and I'm seeing a lot of change there because GDPR requires organizations to notify both individuals and regulators about data security breaches. And of course, this has been a long-standing obligation in the US and some other countries, but it's coming to Europe as a legal obligation. And I think perhaps this is an area which many organizations underestimate. No matter how mature a privacy and security program, everybody can suffer a breach, everybody can suffer a hack, and it's incredibly important to have policies, procedures, incident response plans, teams ready, exercising and practicing, frankly, tabletop breaches as well, so that when these breaches happen, we are prepared, we know how to deal with them. We are also able to notify regulators and individuals as required. And this is one area where, again, I see a lot of change in the past year, organizations kind of getting ready. And then finally, it's going to be really important to manage external relationships, specifically with the data protection regulators. This need for constructive engagement is going to be enhanced by GDPR. As you know, there is going to be this concept of a lead authority in Europe, almost a one-stop shop, but not quite. So it doesn't really mean organizations will have one regulator in Europe. They will have one main regulator and then 27 kind of potentially involved regulators. And so how you manage that relationship and being able to talk to regulators about your program, about the accountability, as well as challenges is going to be really very, very important. And yes, there is going to be an area of legal uncertainty to start with, but it is always the case when we are in this period of change. And I think things are going to start settling, certainly as we go into the implementation. Very briefly, my sort of last remarks, I just want to remind everybody, if we can move to the next slide, please, the need to be accountable, to have this privacy management program. I think this to me is the major change now that we're going to be seeing. Irrespective of legal changes and small rules changing, companies simply have to demonstrate that they are responsible, they have got this privacy program. And here, I've given you sort of the elements of what an effective privacy program should be able to demonstrate. And I think that's what the regulators will also look at as they consider whether an organization has complied or not with GDPR. Moving to the next slide, and these are my last remarks really. I've talked a lot about compliance and I've talked about the accountability, but I really also want to kind of leave you with a message, which is also a positive message, that I think GDPR presents a number of opportunities for organizations. And these opportunities really stem from this accountability. What do I mean by that? Organizations who are smart are really going to be taking some of these positive and progressive aspects of GDPR, like accountability, the risk-based approach, the new need for transparency, certifications, codes of conduct, and really kind of make that part of their data strategy. So link GDPR to the business and data strategy versus looking at GDPR just as another compliance area. Because yes, it is, of course, compliance area. Of course, there's a lot to comply with. It's going to cost, and there are risks, and there are, of course, all kinds of burdens. But I think if we look at GDPR as an opportunity that presents us, we will be more successful in organizations. And those organizations who kind of realize the opportunity of GDPR, I think are going to be much more ahead. And to do that, really, we need to elevate this whole privacy to much higher echelons of corporate world, but also public sector as well. This has to be much more strategic topic that really senior leadership cares about, and data privacy officer has to have authority to actually have that mandate. And my last slide is what I would expect if we can move organizations really to take opportunity from GDPR. I believe this is in their self-enlightened interest, because managing data proactively goes beyond legal compliance, and it's really a business issue that we should care from a business perspective as well, because it does enable us to do more with data. It enables digitalization, it enables global data flows, data-driven innovation. So all the things that companies kind of want to do to grow, if you like, grow economically as well. It also addresses the increased expectation from public and individuals for transparency, for control over their data, and kind of value exchange. How do I trust you as a company? How do I know I get a value from this app or this piece of technology that you're sending to me? So people are interested in that, and I think those companies who see privacy and GDPR as a matter of customer relationship and as a matter, frankly, of digital trust and confidence, they're going to reap many more benefits. I often talk about data not as a new oil, because I don't like that. And, hats off to economists, but I think data is actually a matter of sustainability. It's a little bit like environmental protection. In order to ensure that the data in the ecosystem and it's used appropriately, driving the benefits to health and education and consumer protection and just our life, we need to make sure that the data is used responsibly and it's used sustainably, and it is also protected. Because if we do not believe in that, we as individuals will simply not want to take part in that digital transformation, right? And that's why this, to me, is ultimately a business issue. And as I say, those organizations who are on that track will probably be more reaping bigger benefits. So happy to take more in the Q&A session, but over back to you, Ceren. Thank you very much.
Okay, thank you very much, Bojana. This was brilliant. We already have questions pouring in to be addressed later in the Q&A section. So now I would like to welcome Professor Joe Cannataci. Great having you. You don't see his name on the screen. He is...
Yes, this is, can you hear me, Ceren?
Yes, I can hear you perfectly. It's great having you. Thank you for joining us.
Yeah, I thought it would be interesting to others to see that even when it comes to my own devices, I don't tell them who I am. So that's the reason why you see user. Most of my devices are on user. Yes, I think you muted yourself, Ceren.
I did. Sorry. Yeah, the mystery element is good. So great having you. Without further ado, there are varying opinions on the GDPR. While we have some optimistic views, we also hear some pessimistic views on what to expect after May 25th. I was hoping you could share your insights to give us a better understanding of the big picture of the global impact of GDPR. Thank you.
Yes, well, GDPR is something that I welcome greatly because of the fact that it contributes to the global legal framework. Some people may see it as being a primarily a European instrument, and of course, that's where doubtless the greatest impact will lie. But in reality, we have to remember that privacy is a universal right. It's a fundamental human right, but it's not a self-executing right. In other words, privacy needs rules, very detailed rules out there. One of the good things and the bad things that we have about privacy is that we have in the Universal Declaration of Human Rights and in the ICCPR, the world has agreed to respect privacy and recognize it as a right. The problem, of course, is that they didn't have enough lawyers with them, or else there are too many lawyers, because they didn't put in a definition of privacy. So the fact that we don't have a definition of privacy means that we have to have many detailed rules which help us determine the boundaries of what privacy is, and therefore help us overcome what we have failed to define in the past. Now, this is very important because the world needs a comprehensive legal framework. It needs several tiers of rules, and in those rules, it needs to be able to find a whole bunch of things. It needs to find rules about what companies do. It needs to find rules about how the state stores people's social security data. It also needs to find rules about what happens when it comes to surveillance, when it comes to national security, when it comes to the police. Now, a number of people may have been surprised to find out that the things which led to the creation of my mandate at the United Nations, and very importantly, the whole furore over the Snowden affair, what national security agencies do, how they carry out SIGINT or signals intelligence, how in the intelligence sector people carry out surveillance across borders. Well, here's some news for those people who haven't noticed. The GDPR doesn't tackle any of that. And the GDPR wasn't designed to tackle any of that, right? So this is not a failing of the GDPR. The GDPR was not designed to tackle surveillance for national security. In fact, national security is one of the areas which the European Union is not competent for, but where the member states of the European Union are competent. It's a reserved area in terms of Article 4, subsection 2. Does it mean that outside the GDPR, there is no hope? And I'm going to just go outside for a few seconds and then come back to the GDPR. No. The interesting thing, of course, is that all the 28 member states of the EU are also member states of the Council of Europe. And while under the rules of the EU, they can't talk about national security, actually all of them have signed the Council of Europe's Convention 108. And Convention 108, the European Data Protection Convention of 1981, in Article 9, includes national security, state security as it calls it, as well as law enforcement. So let's make a little mental note as we go on, because those European states have committed themselves to only derogating from data protection rights if, one, these measures are provided for by law, in other words, there must be a legal basis. Two, if those measures are necessary and proportionate in a democratic society. So those tests on necessity, proportionality, democratic society are there, they exist. And those are things which we'll see Europe continue to work with. And let's remember now, not only Europe, there are another 9 countries, including Tunisia, including Morocco, including Argentina soon, who have either signed or about to sign the European Data Protection Convention, making it a much more international instrument. So we have to remember that the instrument must walk in line, in sync. But let's get back to GDPR. Having made that small detour to explain that thing which many people worry about, which is surveillance and national security. Well, the good thing about the GDPR is, and here I'm grateful for Bojana for having given a very comprehensive presentation before mine, and I'm very grateful to that, because as most people can hear, my voice is crackling up. Thanks to what's left of a cold, and also too many planes and too many speeches. But if we go back to the good things about GDPR, is that, like it or not, it constitutes a not so subtle attempt by the European Union at extraterritoriality, right? So Europe is not being too shy about this. It's exporting its standards. Well, that's not such a bad thing, right? I mean, if you look at what happened if we take an analogy of the car for a minute, and we look at what happened in the United States and what is normally known as the California effect, right? When California clamped down on 2 things in the very early 70s, in other words, on pollution and emissions, but also on safety belts, then we saw safety belts being introduced all over the United States and certainly all over the world. It took the Americans some time to get used to it, and then of course they weren't happy and we had to have airbags and other stuff introduced. But in reality, what you see is the introduction of standards and new standards by the back door to a certain extent. How many people bought a car in the 70s and the 80s which had safety belts fitted, but the law did not impose safety belts? So people could still use them and people could still benefit from them. And that, to a certain extent, is pretty much the analogy I will use when it comes to the GDPR, because what the GDPR introduces is a whole bunch of standards that people around the world will have to comply with. Why will they have to comply with? Because if they want to do business in Europe, if they want to have, if they want to somehow treat data belonging to Europeans, or indeed, if it's a software company wishing to sell its software in the European market too, it doesn't really make sense if you're a software company. It doesn't really make sense to have and maintain one set of software programs for the EU and another for the non-EU. What you want to do is have one product and keep your maintenance costs as low as possible. And that is yet another way in which we will see, I think, privacy legislation by the back door. In other words, you'll see a creeping in of standards across the world where people may not need to do it if they are primarily based in a country outside Europe, but they will actually seek that their services and their products will comply with European standards because they want to do so. One typical example, of course, is this of privacy by design, right? I mean, privacy by design and privacy by default. If you are expected to demonstrate that your product complies with certain standards, in this case, European standards, then you are well placed to show that your product shows privacy by design. Is that going to hurt if you're going to be based in India, the United States, in Australia? So of course it won't hurt, right? It can only help improve things. But what that means is that the products being used in countries outside Europe will also have this privacy standards by the back door introduced. So actually, I'm quite pleased about that because it's going to help drive up standards. One final word in order to help you keep on track, and Bojana will owe me a drink on this because she was so comprehensive that she was nearly 20 minutes going. I'll pick her up on privacy engineering. I think from all the diagrams that she showed, I think the most important thing is privacy engineering. In fact, I'm trying to talk the big companies, including Cisco and Microsoft, etc., to sponsor chairs of privacy engineering, because up till now, if you speak to the engineering folk, they've been very happy to aim something aspirational. This kind of engineering, this kind of software engineering, security engineering, cybersecurity engineering. But up till now, privacy engineering hasn't been a catchphrase. And that's one of the things I think we should be introducing, because in order for you to really have privacy by design, and this is something we need across the whole world, not just in Europe, you need a whole bunch of privacy engineers out there. So I'm going to stop here for now, and I would look forward to the rest of the discussion and to the Q&A. Thank you, Ceren.
Thank you very much, Joe. Thank you. This was brilliant. Now we will go on with Olivier. You have great experience as a privacy lawyer working with domestic and international clients, and you are also working on various projects on data protection with our French chapter as honorary president. How do you see the GDPR reshaping the way businesses operate, particularly now that we have strengthened rights for data subjects, including high criteria for consent?
At first, thank you for inviting me, and hello to everybody from Paris. You asked me to speak about the GDPR in a practical aspect. So this is not the easy part of the job, as you know. You know, I have a picture just behind me. It's a fisherman in the sky with, he's fishing a Rubik's Cube. This is a GDPR. The GDPR is in the sky, and we have to put it on the ground, you know. GDPR means today big words, as new words as privacy by design, as Joe just said, or security by default, accountability, even words like controller and processors. We don't know exactly who is who, and there are new concepts also like giant controller. For example, Bojana spoke about right of portability, and right of portability is mandatory for controller, not for processor. So this is not neutral, and the text is not ready to read. You have just in the introduction, you have 170 paragraphs and 99 articles. And also, the GDPR implies multiple skills, of course, legal, but also, as Joe said, engineer. And, you know, the personal data is everywhere in a company. So it's a change of mentality in a certain way. What I think that the purpose of the regulation is that, because in countries like France or Germany, you had a regulation like that for Germany and France since 40 years. And the purpose are the same. The principles are the same. For us, Germany and France, this regulation, GDPR, is not a revolution, but an evolution. So I just would like to say a few words about the micro, small, and medium-sized enterprises, because for them, GDPR is a nightmare. You know, so you have to face multiple concepts, multiple new obligations, and they have no resources. And they need time. And the May 25th, it's in few weeks. So that's a big problem, and it's a kind of pity that the regulation didn't make a difference between big companies and small and mid-sized enterprises. So what I can say in few words, in few minutes, to implement the GDPR in a practical way, I think there are two key points and two key measures to take. The first one is the record of processing activities. It is under the Article 30 of the GDPR. It is mandatory for both the controller and the processor to record the processing activities. And this is very important because it enables the company and organizations just to know what the data they are processing, because most of them, and especially for small companies, they do not know which kind of data they have. And as Bojana said, you can see with the record of processing activities that the GDPR is an obligation, but can become an opportunity, because if you do the effort to make the record of processing activities, maybe you can discover assets and you can act differently. And to make the record of processing activities, which is a key point of the GDPR, and the start to comply with the GDPR, because you have to know what you have in. You can also imagine, or you can also change the way how to process it. Okay, because after you do the record of processing activities, the lawyer, the attorney, plays his role. When you see the record, After that, you have to understand what are the processing, where do the data come from, do they comply with the consent, etc., etc. And the purpose of each processing, is it legal or not? So you have to make a legal audit of the processing. So the first key point to engage a compliance with GDPR is the record of processing activities. And the second key point is the contracts, because probably the GDPR, we don't see that today, but I think this is the most important part of the GDPR. It will change the relation between clients and suppliers. I mean, between controllers and processors, because you have in the GDPR articles who are very, very important to understand this new relationship between supplier and client and between controller and processor. You can see that at the article 82, which titled is Right to Compensation and Liability. And it says, I just read few words. Any person who has suffered material or non-material damage as a result of an infringement of the regulation shall have the right to receive compensation from the controller or processor for the damage suffered. And the section 4 of this article adds, each controller or processor shall be held liable for the entire damage in order to ensure effective compensation of the data subject. It means that we speak in terms of liability also in the GDPR. It's not only a matter of course, it is a matter of purpose regarding the data subjects, the right of the personnel, of the natural persons, but you can see it also in terms of liability between actors, between players, and this is an important part of the GDPR. That's the reason why with the record of processing data and with the review of the contract, review means that probably you have to, and this is for sure at probably 99%, you have to change your contract, you have to amend your contract, because you have to take into consideration those changes. These are the two main key points of the GDPR in terms of compliance. And I will say in conclusion that GDPR compliance means, of course, obligations. But as Bojana said, and all the speakers said, we have to change the situation in opportunities that must become an opportunities. And it means that the rules must be followed by all the players, not only the European players. That is very important for the European players, the European company. They must feel that this is not just for them, this is for all the players, including their competitors. So I think that the Data Protection Authority should enforce also the compliance in terms of fair competition. So this is a very important part of the GDPR for the European players. And I remain at your disposal for any questions.
Thank you very much, Olivier. Another announcement for the audience. We're going to launch 3 very quick poll questions, and we look forward to hear your ideas as well. I think you can now see them on screen. Now it's the time to hear the DPA side of the story. The GDPR is a game changer, not only for businesses and controllers, but also for data protection authorities. Nevena, you also have a unique local experience being from Serbia with the ongoing accession negotiations to the EU. We would really like to hear your views on the challenges for the EPAs with regard to harmonization and compliance. Thank you. And I think your slides are ready too.
Okay. Before going to my slides, first I wish to thank Internet Society for organizing this. For example, you've been very active in drafting modernization of a convention mentioned by Joe. So this is Convention of the Council of Europe on the protection of individuals with regard to automated data processing, and it's actually the first binding document, internationally binding document on data protection, adopted back in 1881. And back in a few years ago, we were working on modernized convention, and both Christine and Robin, on behalf of Internet Society, were active in participating in our meetings. And this is also important that Joe Cannataci, as UN Special Rapporteur on privacy, mentioned convention, in particular the Article 9 and how it applies to national security issues, which are not part of GDPR for known reasons, as Joe has explained. And one addition to promoting also not only GDPR, but also Council of Europe work, being a member of the Bureau, is to say that it's also open for non-Council of Europe member states. And it's interesting how GDPR actually affected the work of Council of Europe, that many non-Council of Europe member states wanted or expressed their will to become a member states of the, or participating states of the convention. This is a positive effect or radiating effect of GDPR throughout the world. Bojana also mentioned something that I think it's very important to say about the work of Working Party, Article 29 Working Party. This is a very good source of laws, in particular soft law and interpretation. And for all of us that are interested in what GDPR means, as Olivier said, it's a lot of preamble. It's a long preamble and long list of articles, especially paragraphs within articles. It's a very good source of interpretation and comprehension of the examples. And we can go to my slides, and I would agree that this is a part of evolution rather than revolution, because sometimes I read GDPR and think that this is actually an example of how we write it down, common sense and good practices, common sense in terms of data protection rights, but also good practices in terms of importance of the role of, for example, data protection officers, or to implement privacy by design, or conduct privacy impact assessment. That being said, I go to my presentation, which is full of text, but I go through it. I would just, for the sake of history, put all the parts, not actually all the parts of the articles, because there is no space for that, to see another perspective, what actually GDPR also tells us. So if we may go to next slide. So this is actually a duty to establish data protection authority, and for all EU member states, that's a must. It could be one or more, and there are members of the European Data Protection Bureau, which would be a very important institution or authority, issuing all those guidelines or practical rule books on various issues of GDPR data protection, and perhaps some that are not even tackled by GDPR. Okay, these are the list. Okay, thank you. We can go back. It's also actually compulsory for non-EU member states, especially if those states want to have an adequacy decision, because what is looked into the whole system, legal system, is the existence and effectiveness of an independent authority. For example, Canada, that possesses this adequacy decision, is a nice example of having privacy commissioners on each state level, but also on federal level. And it is also essential for countries that are candidate countries, or those that sign the association agreement with the European Union, because this association agreement as a rule, contain an article on data protection, also including establishment of independent authority. So we can go to next slide. So this is the chapter whole 6 of the GDPR deals with the independent supervisory authority, and we can divide those issues, for example, in institutional independency, that they should be totally independent in performing their task, no external influence. They should refrain from other activities or duties that are not incompatible with the duty of data protection authority. For many countries, it is what was important to put is also to have sufficient resources in terms of human, technical, and financial resources, infrastructure and premises as well, to be able to choose their own staff, and financial control should be as independent as possible. That, of course, would depend on each and every political and legal system, but the financial independence and also revision means that there will be an audit, independent audit institution that would audit the finances of the authority. Can we go to the next slide? Tells about personal independence and capacity, and deals with the members of authority to be appointed, to be qualified for that, to be long in the office, but dismissed in cases of misconduct, but in cases of serious misconduct. These are all guarantees of data protection authority independence. Next slide shows us that, well, that it's compulsory for a member state to have a law establishing data protection authority, and what this law should include. They're also bound by professional secrecy, and of course to have annual reports submitted to the public or to some other authorities. Next slide is actually so when we were talking about GDPR, and when GDPR was debated and adopted, we all were talking about the role of data protection authority in terms of their investigative or corrective powers. And one of, perhaps too much attention was put into this fining possibility that the data protection authority can fine, and those fines can go up to 20 million euros, and everybody was scared about it. That is something that can be scary. But what often we say is, what often we don't say is that apart from these investigative or corrective powers, there is an advisory power of data protection authority. And this is evolution also in terms of data protection authorities. If we go to next, can we go to next one slide? So we can, but there is a list of powers when it comes to advisory powers, but we can divide them into those powers advice to national authorities, not only national parliament when they're drafting the law or in the process of adoption of the law, because what the data protection authorities are is actually they're in fact extending hand of legislature, not the executive. So this independence is actually the focus on independence is independence of data protection authorities from the executive power rather than the legislature. Then they should, or we should, advise a government or other bodies while drafting or amending laws pertaining to personal data protection. We also should advise public on how to keep their data, how to protect themselves, even from themselves. So this is also a role of data protection authority, and also perform other powers with regards to binding corporate rules, contractual clauses, and certification. Some of those Bojana already mentions, and of course advises control. So this actually power, advisory power of data protection authority, is a duty that corresponds to the list of duties that controllers have. And this is something very important to have in mind, in particular if one is acting on behalf of data protection authority. So GDPR is not only a list of obligation and duties for data controllers and processors, it's also a list of duties for data protection authority. So can we go to next slide? So these are some examples. For example, the controller and the processor have a duty to cooperate with supervisory authority. But this duty to cooperate with the data protection authority for controller or processor is also duty to cooperate for data protection authority. Privacy impact assessment, and the whole article is dealing with a prior consultation, and that actually involves data protection authority from the very beginning of establishing privacy impact assessment. So their role is very important. They, not only that they have to be knowledgeable about data protection authority, they should also have staff that is skilled in technology, not only law and other sciences, but technology is very important. And I think that many of data protection authorities, including my own, lack actually sufficient staff skillful in IT. But we should be involved from the very beginning. And then the task of data protection officer always involve cooperation or consultation with the data protection authority. The next slide is also a list for it's also an example of how data protection authority must cooperate when we draft codes of conduct. So they're involved from the very beginning of the drafting process. And I think this is important to emphasize that this this role of data protection authority has evolved from being. Can we go to next slide? From being. Can we go to next? From being more focused on the action after the following takes place, like for example, the enforcement, the monitoring of the implementation of the law, investigative powers, corrective powers, and even punishing. Yeah, and there is a huge shift to activities and powers and duties prior to data processing. So the role of a data protection authority under general data protection regulation is to be more preventive, to be cooperative, to be proactive, to advise, to raise awareness, and to be as inclusive as possible. So I think we could see data protection authority as supervisor or mentor at the university. So the failure of a student that could be a data controller could be also seen as a failure of data protection authority, because we have not invested much in educating and helping controller and processor to comply with the national law on personal data protection and general data protection regulation. I think that's my last slide, or yes, okay, thank you. So actually, I think that is also important to emphasize that the GDPR affects not only SMEs or data controllers outside Europe as well. It also affects to a large extent, data protection authorities in their capacity and their knowledge and understanding of the role, that they're not there only to guard, they're there to advise and be always available at request or full time. Thank you.
Thank you very much, Nevena. This was really interesting. The university mentor-student analogy was really interesting. Now, before we move on to the Q&A session, let's have a look at the poll questions that we asked our audience. We asked our audience whether they knew their rights under the GDPR. 66% said yes. We asked whether they believed their rights will be better protected under the GDPR. 63% said yes, 7% said no, 22% said don't know. And we asked whether they believe GDPR is going to minimize breaches. 46% said yes, 27% said no, 28% said don't know. So with this information, I would like to ask the speakers, our experts, do you think the GDPR is going to improve trust as a whole? Can we say that? And also with regard to, we have some very interesting questions. we have one question on whether end users are going to be asked to pay more for what used to be free services just because they want to have increased privacy protection. And economic impact of the GDPR and how much would it cost to comply? Joe, please.
Okay, I'm going to start with the last question, because that's very easy. The GDPR is going to cost more, and many companies are complaining about it. The fact that it's going to cost more means that ultimately the cost is going to be passed back to the customer somewhere around the world. But that was not the main question I wanted to address. The main question I wanted to address is, will the GDPR increase trust? Quite frankly, I don't think the trust has anything got to do with the GDPR. I think the trust will largely depend on the way the companies behave, on the way the governments behave, and on the way that the media treats the behavior of the government and the companies. So the GDPR may work perfectly well, but because the governments screw up when it comes to surveillance, for example, the citizens out there will confuse things and they won't have trust. The GDPR may work perfectly well, but if the companies are not sticking to the spirit of the GDPR or the spirit of indeed anybody else's privacy law, but are in fact trying to make the most to monetize personal data without this being completely transparent to the citizens and to the users, then at some point in time, it is inevitable that citizens, users will feel shortchanged and they will lose trust. In both of these cases, it's got nothing to do with the GDPR itself. I'm suggesting that trust has all got to do with other things in life, and the GDPR can help reassure people that something is being done, and in fact, sometimes it will be done, but I don't think that it's going to work well with trust at the individual level. When it comes to countries and companies, that's going to be something else. I mean, frankly, just because there's the GDPR, does this mean that the European Union is going to trust the Japanese more, or trust the Chinese more, or trust the Americans more when it comes to the processing of personal data? I dare say not. It's good. There will be other factors which will influence the trust or lack of trust between countries. At this moment in time, we are seeing adequacy procedures being carried out between Japan and the EU. Will the GDPR impact this? Well, to a certain extent, yes, in the sense that the European Commission will want to see whether, excuse me, Japan meets the minimum standards prescribed by the GDPR, but at the same time, there will be many other things outside that which will could possibly impact the trust that takes place, because there are some countries which, on the face of it, may meet certain minimum standards, but in practice they don't. So I think that trust and GDPR can be taken up in completely different discussions and may possibly never meet, at least intentionally. Thank you.
Thank you very much. We also have some questions about non-EU countries. How do we define non-EU countries, and how do we define EU residents?
Yeah, I just would like to add something, if I can, Ceren. Can you hear me?
Yes.
Yeah, about trust, because this is a very important question. I think that one of the purposes of the regulation is to enhance trust. I do agree with Joe that regulation is not enough. But one purpose of this regulation is to change the behavior of companies and governments, because I just want to remind to everybody that state members of the European Union are subject to regulation. They are controllers and they have to be controlled, and I expect so punished if they infringe the obligation. And I just want to add something, one just point. The GDPR gives the opportunity to each member state to implement in its local law class action about personal data. And I think that this is a very important part of the GDPR. We can't let only the data protection authorities to deal with the personal data. It's a matter for citizens. We have to take back our own destiny with the personal data. And the GDPR, and I think that's the case in Austria and in France, where the parliament is voting a law now to authorize the class action with personal data. And this is a very important thing, and that can help to enhance trust among the citizens, which is very important for the future of the information technology.
Thank you, Olivier. That was very.
Ceren.
Yes, of course.
Can I?
Yes, please.
Yes. Can I address the same question?
Of course. Are you on mute?
No. Okay. Is that better? So I'd like to address the question of trust, but also the economic impact. I thought that was a really smart question. How do we measure economic impact of GDPR? And I would actually link the two questions. How do you measure effectiveness of this law? Is this law really going, what's the objective of the law? To protect people, to deliver better privacy on the ground? Is it going to deliver that? And that is part of the trust, but it goes beyond. And I think, yes, it should. It really should. If the accountability becomes a leading principle and it gets implemented properly, then we should have, theoretically and practically, organizations using data more responsibly, being more transparent, having less breaches, potentially being able to deal with individual complaints and rights and so on. And I think that's the positive, right? That's what we really want to happen. And that will then build, hopefully, more trust. But in order for this to happen, we need organizations to step up, but also to Nevena's point, we need smart data protection authorities. They're supposed to also be effective and strategic to actually ensure that the marketplace behaves in a certain way. And so I think for DPAs, the question is going to become, how do you get the best behaviors in the marketplace? Do you do it through carrot or stick? Do you do it by imposing 4% sanctions, or by incentivizing good behavior, showing what the good looks like, cooperating, collaborating? I like a lot the things that Nevena talked about. Please go to our website. We wrote a paper on this, Regulating for Results, which actually talks about what the effective privacy regulator should be doing to achieve the best goals. And I think it really depends on the both. On economic impact, I think it's a fantastic question. We need, if anybody that is out there listening to us, if you're working on this, let us know. I'm very interested to collect anecdotes and some evidence. For example, Cisco, who is one of CIPL members, and they work with us, has just published a 2018 privacy maturity study. I'm sure you can find it on the website. And there, they have measured how much privacy concerns impact the delays and bring delays in commercial negotiations between businesses, say outsourcing or IT services or whatever, right? They did that across 36 countries. And the interesting data is that, first of all, there is no doubt that on average, concerns of data privacy add to 7.8 weeks of delay in business negotiations. Now that is the cost, right? 7.8 weeks means cost to organizations, cost of doing business. And the companies who have got more mature privacy programs, their average was 3.4 weeks, whereas the companies who didn't have mature programs, their average was 16.8 weeks. Now, to me, that's a direct correlation, a direct economic cost of actually privacy being good for business. And if you manage properly your privacy and vendor management and relationship, then this should not be a delay in your commercial negotiations. equally also, this is from my previous life. I used to be head of privacy at Accenture for about 12 years globally. And there's no doubt that we have seen an economic impact on being a good business partner to the clients, helped actually seal some deals, sell some deals, and then deal with the problematic deals when there was a problem as well, because those customers wanted to trust us, and they trusted the company. And Accenture does amazing things now still, where they're really using data privacy as a competitive differentiator. And I'm seeing more and more companies in the services industry, specifically in cloud services, even Microsoft, Google, Amazon, certainly Apple in the consumer business as well, teleperformance in outsourcing, they're using GDPR as a positive to drive business. So I think that's the beginning of that data, but let's collect more.
Okay, thank you very much, Bojana. Yeah, it's a very good incentive for businesses as well, for compliance, obviously. We are also, one of our participants asked, how will it work for, say, non-EU? I'm from Kenya, and I'm trying to see how exactly Article 45 transfer of data to third countries would work for them. Who would like to address that in the panel? And we also have some questions about the definition of EU residents and application, the extraterritorial scope of GDPR, basically. Nevena, would you like to give?
Well, but this is actually a procedural question on this, the adequacy decision that the Commission would pass or would not. But this is the evaluation process. That would depend on the will of the, for example, Kenyan authorities to apply for adequacy decision and then be screened by authorities. Like, for example, we learned that the Commission is re-examining adequacy decision that have already been done under the Data Protection Directive of 1995, and they will re-examine each and every decision. And then currently we know from media that Japan applied for adequacy decision of the Commission. So not only that the representatives of the EU, but not only Commission, but also some of national data protection authorities would go and inspect on the spot, not only Data Protection Authority, but also other institutions and the rule of law, for example. And then also the examination will take place, the screening of the documents available. I think that's a procedure. The length and the depth of the procedure would depend on a particular case and therefore the decision. So this is under Article 45. This is a data transfer based on adequacy decision.
Ceren, do you want me to address the question of the extraterritorial application? Yeah. Okay. So this is really important, actually. As Joe has said, Europe is trying to impose its level of privacy protection through two ways. One is through the data flow provisions and adequacy and other mechanisms, and the other one is through the Article 3, for those of you who love to read legal articles, which is the extraterritorial application of GDPR, meaning that for organizations that are established outside of EU, they will have to comply with GDPR under two circumstances. One, if they target individuals with products and services in Europe. So it's a website that, for example, has got delivers to EU or sells products to EU citizens as well. And two, where these foreign services also monitor activities of European citizens. So it's not, the application of the law is measured by establishment of the controller. So if you're established in the EU, the law applies to you, but also if you're not established in the EU, but you're offering goods and services, targeting individuals or monitoring their behavior, the law will apply to you as well. So really something to look at.
Thank you very much, Bojana. I'm afraid
maybe just for the Article 45, for the transfer to a third country. This is a very good example because there are no real changes. between the Directive 95 and the new regulation, you know. And about what Bojana just said, this is absolutely true. If a company established outside European Union and they target European citizen consumers, for example, they are, in theory, they are subject to regulation. The big question is how to control these companies outside Europe. Can you go by fight to this country and make a control? No, that's not possible. So this is a big challenge of GDPR for the next month.
That's the million-dollar question. I'm afraid we're running out of time, and of course, we never have enough time to discuss the GDPR as a whole. It's a very big, ambitious legal regulation. I would like to turn to our speakers for some really quick final remarks and then wrap up. Joe, would you like to go first?
Well, I wouldn't, but I will. No, it's okay. I'm just kidding. I think it's going to be a very interesting period. I'd just like to remind everybody, though, that the international legal framework that I was talking about first needs to be beefed up on many fronts. So we have also, as part of the mandate, in conjunction with the EU-supported mapping project, been working on a draft legal instrument on surveillance and privacy. And I think that what we'll see eventually is a growth of other parts of privacy law, whether dealing with surveillance, whether at the constitutional level, even at the regional level. And the GDPR will be part of this mosaic, part of this, but a very important part which will help influence things in the right direction, I think. Thank you.
Thank you very much. Bojana? Oh, we cannot hear you.
What I'd like to say is that, first of all, I would like to see more convergence globally around how we think about privacy. And I think this is something that we as CIPL try to do as part of our mission. It's important that as new countries are thinking about regulating privacy, that they do it in a way that is more convergent. That doesn't mean necessarily copying GDPR, but certainly having this principle-based approach, having the same principles, and then having some good, positive, progressive tools like risk-based approach, certifications, accountability as well. And my second message is really it does boil down to accountability. I, as a citizen of the world and a consumer, don't want to have the burden to non-stop worry about how my data is going to be used as I travel around the world and work and use technology. I really want businesses and public sector as well, because it's also about public sector compliance, to use my data responsibly with rules and tools and compliance in place. And I think that's what is going to make the difference, really. So I would hope that that's how organizations approach this, as a really something that is going to help them look after their really important asset, which is data, and look after their customers and citizens or consumers, whoever they are.
Thank you very much. Olivier?
Yeah, I would say one word: hope. Hope. GDPR is a hope, not only for all the citizens and data subjects, but also for the future of the information technology, information society. And it will depend on one thing: how it will be implemented and also enforced, not only by the data protection authority, but also by courts and citizens.
Thank you very much. Nevena?
Difficult to add something at the end, but just to continue what Olivier said, I think it's a great challenge for data protection authorities and other institutions. Very important, because if states had agreed to adopt such a long list of duties, they should be able to perform that they're exemplary in data protection. So I think that there should be a huge expectation from the states, from the member states, to respect personal data protection and privacy of their citizens. And by doing that, they can then demand that others follow the example. So perhaps that would be one of my conclusions. Another conclusion is that four of us, we are all lawyers. So I think it's also that personal data protection and GDPR should always be discussed by various representatives of various sciences. Lawyers kind of monopolize the topic of on personal data protection and privacy. But I think we should always be aware that we have no clue about IT, even though we are knowledgeable and we took some time and took several courses, etc. But that we need that knowledge, and not only the knowledge in terms of skills, but understanding how this functions and why this is necessary. And the mindset of a lawyer and IT specialist is totally different. So I think it's also important for us to understand that we need others on board as well.
Thank you very much, Nevena. This was an excellent end note, the call for multi-stakeholder, multidisciplinary dialogue to tackle these issues. I'd like to thank you very much to all our four panelists for joining us today. Virtual applause, all in order. I hope the audience enjoyed it as much as I did. Thank you very much for all the participants from all around the world. Sorry about the questions that had to be left out due to time constraints. We hope to see you again in another time. And thank you very much. Thank you very much for joining us all. Bye-bye. Thank you so much.